most of the H1B workers are being allowed to work from home. Mm-hmm. Now, I have two different questions here. Mm-hmm. They have a worksite address on the LCA. Mm-hmm. Now, overnight, now they started working from home. Sure. What are the LCA requirements if they're in the same MSA? And what if, somebody works in California, now they're from New York, and they start working remotely from New York? Now, what happens should there be a site visit? Are there any exception to this rule?
Okay, so let's talk about within the same MSA. So 90% of people will work where their job is, even if you're in staffing, right? You have probably relocated and you are working for an end client, and you are most likely living, within the Metropolitan Statistical area, which is the MSA. There's also the rule of thumb of commuting distance, okay? Now, it's not like a rigid rule of 10 miles, 20 miles, 30 miles. I normally tell clients it's about 50 miles or so is about a reasonable look, where we can make the argument that the home address or maybe the new location, if we weren't in this type of situation, is within commuting distance. But if let's start with the basic of the MSA, if your home location is within the same MSA as the work location that's listed on the LCA, then all that needs to be done is the LCA posting notice needs to be posted at the home office of that individual. After that posting notice is posted for 10 days, it is taken down, and the employer should then put that in the individual's public access folder. No amendment is necessary, just the posting notice. Not an LCA, the posting notice needs to be put into the home office location. Okay, so that's MSA, okay? Now let's say you have that 10% or 15% of individuals who are working in California, but their home is, it's a temp project, it's 3 months, 4 months, they're not moving their family is in New York. Okay, very different situation and different rules may apply here. So in that type of situation, home location is not the same MSA, so what has to happen? Well, one option is to use what's called the short-term placement rule, which allows an H1B applicant to be at another work location, and that's what that would be. It's remote working, right? But it's now at a home for at least 30 days out of 365 days, and you do not have to file a LCA or a H1B amendment. It means also there can't be another LCA for that location. So if you have an individual in LCA location is California, let's say San Jose, but they live in New York, and they have to now work from New York, you can try to use the short-term placement rule for 30 days. Now, what happens if you say, Nandini, hey, we look like this is going on for longer than 30 days, then an amendment will have to be filed to include that home location.
Okay, so at least for now, if this goes past, as the President Trump stated, this might go up until August, right? If nothing happens, they continue to work from home, so they have to initiate an amendment after 30 days.
Yes, that's the only option available at this time. Again, we may have different options available if, CIS and Department of Labor get their heads together on this and understand the dire situation the foreign nationals are in. But for right today, this is what the only available route.